Hello and welcome to Verdictum. This is Kanchan and today I am going to explain to you a few interesting judgments of this week from the Supreme Court. A two-judge bench of Justice S. Ravindra Bhatt and Justice Dipankar Datta observed that in the facts of the present case, the award did not facially disclose any error of law. Damages were awarded in accordance with principles embodied in law and the findings were based on the evidence placed before the tribunal. The ruling of the trial court and the High Court is nothing short of intense appellant review, which is impermissible in law and beyond the court's jurisdiction. The appellant, a contractor for a government project in Maharashtra, faced delays in a canal construction task. Extensions were granted due to a non-contractor related delays. The contractor sought arbitration as per the contract, and an arbitrator was appointed by a civil judge to resolve extra work disputes, who awarded the contractor a significant sum along with 12% interest from December 10, 1988 to arbitration start and rejected the state's counterclaim. The state challenged this under Indian Arbitration Act Section 30 and 33, citing legal misconduct. The trial court revoked the award, leading the contractor to appeal to the High Court, which upheld the decision. The Supreme Court delved into the relevant contract clauses. It was noted that Clause 54A dealt with dispute settlement procedures, requiring parties to seek written instructions from the executive engineer (EE) within 30 days when a work was deemed outside the contractor's requirement. If the EE's decision was unsatisfactory, the contractor could appeal to a higher authority with a 60-day deadline for their decision. Clause 55A stipulated arbitration matters, and Clause 58 covered compensation for delays. The court emphasized that the state's argument that the claim crystallized upon the issuance of the final bill on December 14, 1922, which was valid. The contractor's payment-related concerns were first raised with the EE in 1988, with subsequent unsuccessful appeals to the superintending engineer. Therefore, the claims submitted to the civil court in January 1955 was within the limitation period. Addressing the question of claims not adhering the 30-day period post-contract foreclosure, the court held that due to the multiple extensions and mutual consent leading to foreclosure, this argument wasn't applicable. The contractor's request for foreclose in their letter dated April 6, 1990 was accepted by the department, making the delay in submitting the claim reasonable. Consequently, the Supreme Court set aside the impugned judgment, restored the award, and directed the state to ensure full payment to the appellant in line with the award within the 8 weeks. The appeal was allowed and the appellant was granted cause throughout. The two-judge bench of Justice J.K. Maheshwari and Justice K.V. Vishwanathan observed that as the respondent was not involved in heinous or serious offences or any offence including moral turpitude, and the fact that in the said criminal case he has been honourably acquitted, therefore modifying the order of the High Court, we direct the appellant to consider the case of the respondent and issue order of appointment to the post of constable in West Bengal Police Force within the period of 4 weeks from the date of passing this order. The case involved an appeal against a judgment by the Calcutta High Court concerning the appointment of Mithul Kumar Jana as a constable in the West Bengal Police Force. Despite being placed on the merit list, concerns arose due to his alleged non-disclosure of an ongoing criminal case on the police verification form. The appointing authority sought an opinion from the intelligence branch, which confirmed non-disclosure. Consequently, the appointment was denied. The respondent approached the West Bengal Administrative Tribunal, which stated that the non-disclosure wasn't a suppression of material information and suggested considering the appointment under acquittal. Displeased, the respondent appealed to the Calcutta High Court. The High Court determined that the form asked for details about arrest, detention and conviction, not pending cases, and ordered the appointment letter issuance, citing the respondent's presumed innocence. The state of West Bengal appealed against the High Court's decision. Upon examination, the court found out that the respondent has been acquitted of charges in a related case. The court noted that the allegations weren't of serious nature and wouldn't affect his public employment. The tribunal and the High Court have rightly recorded the findings that it is not a case of suppression of material information, and we affirm such findings. Simultaneously, the criminal case registered against the respondent were for petty offences. The allegations in the said case were neither of heinous or serious offences nor related to an offence involving moral turpitude. In the said case, the respondent was honourably acquitted because the prosecution had miserably failed to prove the charges. The court discussed the language of the verification form and cited a previous case, B. Chinnamai Naidu, to assert the respondent's response aligned with the form's requirement. The court then referred to the case of Avtar Singh versus Union of India and others, summarizing principles related to the suppression of information. Consequently, the court confirmed that the respondent has not suppressed material information and modified the High Court's order. It directed the appellant to issue an appointment letter to the respondent considering his acquittal. The court emphasized the discretion of the employer in assessing suitability and antecedents and specified that the respondent would receive national benefits upon appointment but not salary or back wages until the appointment date. The appeal was disposed of accordingly by the court. The two-judge bench of Justice M.M. Sundaresh and Justice J.P. Pardiwala held it is always open for the accused to raise any legal ground available to him relating to the legitimacy of the TIP or the evidentiary value of the same in the course of the trial. However, the accused cannot decline or refuse to join the TIP facts which establish the identity of any person or thing whose identity is relevant are, by virtue of Section 9 of the Evidence Act, always relevant. The term identification means proving that a person, subject or article before the court is very same that he or it is alleged, charged or reputed to be. Identification is almost always a matter of opinion or belief. The appellant, along with 3 other co-accused, was put to trial in the court of the additional sessions judge for the offences punishable under Section 392, 394, 397, 307, 302 and 411 read with Section 34 of the IPC. In 2008, during the early morning, the first informant, along with his friend and brother, were at a sabzi mandi for purchasing vegetables. When they proceeded towards the main gate after the purchase and reached near the STD PCO, the 4 accused persons cornered them. 2 of the accused persons snatched away rupees 1400 from the pocket of the first informant, and when he resisted, the other accused, armed with ice picks, attacked him and his friend. The accused ran away from the place of occurrence, and when the traffic of trucks at the market got eased, the first informant saw his friend lying in an injured condition when he was admitted in the hospital, but he died over there. During the investigation, the officer decided to hold TIP of the accused person, but the appellant refused the same. The appellant, being aggrieved by the decision of the High Court, which upheld his conviction, was therefore before the Supreme Court. The apex court, in view of the facts and circumstances of the case, observed during the investigation of a crime committed by persons unknown to the witness, the persons arrested on suspicions of their complicity in the crime have got to be confronted by the investigating authority with the witness so that they can find out whether they are the persons who committed the crime or not. Since it would be very easy for a witness who has little regard for truth to say that the persons arrested on suspicion was the offender, he is confronted with the suspect mixed with innocent men. If he picks him out, then that would add to the credibility of his statement that he was the offender. This is the primary object of identification proceeding. The court said that as per the settled law, if a witness is trustworthy and reliable, the mere fact that no identification parade could be conducted and the appellant convict was identified for the first time before the trial court would not be a reason to disregard the evidence of the witness. The court also observed that although the appellant in his further statement recorded under Section 313 CRPC stated that he had refused to participate in the TIP as the eyewitness has already seen him, yet except a bad assertion, no other foundation has been laid for offering such an explanation. The court, however, noted that even if the evidence of discovery is disregarded on the ground that no independent witnesses were present at the time of discovery, still the fact that the appellant led by the police party to his house and handed over the ice pick used at the time of the assault would be reflective on his conduct. The court concluded that the appellant was guilty of his act but considered the fact that he hailed from a very poor family and was undergoing sentences for more than 16 years. Hence, it granted to him a liberty to file representation to the competent authority for his premature release. Accordingly, the Supreme Court dismissed the appeal and upheld the conviction of the appellant. A three-judge bench of Justice B.R. Gavai, Justice J.P. Pardiwala and Justice Prashant Kumar Mishra observed that it is unsafe to record the conviction on basis of a dying declaration alone in the case where suspicion like the case on the hand is raised as regards to the correctness of the dying declaration. In such cases, the court may have to look for some corroborative evidence by treating the dying declaration only as a piece of evidence. The appellant convict was appealing through a special leave against the judgment by the Allahabad High Court. The High Court had affirmed the conviction and death sentence passed by the additional sessions judge. The prosecution claimed personal animosity as the motive due to the opposition to the convict's second marriage. The trial court found the appellant guilty and the High Court upheld the decision. The court noted that the case revolved around the admissibility and reliability of dying declaration as evidence in a criminal trial. After reviewing the materials on record, the primary question before the court was whether the prosecution had successfully proven its case beyond a reasonable doubt against the appellant convict. The court noted that the appellant convict has a strained relationship with the deceased person and was accused of setting a room on fire, resulting in their deaths. There were two dying declarations made by the deceased person, but the oral evidence of the eyewitnesses PW2 and PW4 seemed contradictory to the dying declaration. The court found discrepancies in the dying declaration and the oral evidence. The oral evidence claimed the presence of an eyewitness at the scene during the fire, whereas the dying declaration stated that the neighbor had rescued the victims. Additionally, inconsistencies in the detail of the incident and the fact that inflammable substances might have not been directly poured on the victims cast doubt on the prosecution's case, the court noted. The court delved into the principles governing dying declaration, emphasizing that they are admissible due to the solemnity of a person's imminent death and their presumed honesty in that state. However, the court highlighted that caution must be exercised since dying declaration lack the cross-examination process and can be influenced by various factors. Furthermore, the court analyzed the circumstances of the incident and statements made in the dying declaration state and the oral evidence. Ultimately, the court concluded that neither the dying declaration nor the oral evidence were entirely reliable or consistent. As a result, the court stressed on mere suspicion or strong accusations in a dying declaration are not sufficient for conviction. The Supreme Court further laid down certain factors that can be considered to determine the weight of dying declaration, but not its admissibility. The court ruled that the prosecution had not proven its case beyond a reasonable doubt based on the available evidence, and thus the appellant convict could not have been convicted solely based on unreliable dying declaration and contradictory oral evidence. The court allowed the appeal and acquitted the appellant convict of the charges leveled against him. Thank you and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the latest legal developments.